Hello friends, this is Rajeshwari. If you're holding in your hands our sacred book, the Constitution of India, and about to turn its pages, please hold on. Hold on, because when you approach a subject, unless your perspective is correct, your image, your opinion, your understanding of the subject will also not be correct. It will be faulty. And I need to say this because in our law schools, the Constitution of India is introduced to us as a hodgepodge constitution, as a bag of borrowings that borrowed institutions and provisions from the then existing constitutions of the world and gave to us this hodgepodge. Friends, if you also hold that type of image, opinion about the Constitution of India, I tell you, you're doing a grave injustice to the statesmen, the intellectuals, the philosophers that constituted the Constituent Assembly that gave to us this Constitution. So, with all reverence to that galaxy of statesmen, that galaxy of stars that rarely gathers under one roof, with all respects to them, I would like you to join me in understanding the Constitution of India again. So those amongst you who know the Constitution, who have read, kindly join me and revisit the provisions of the Constitution. Friends, of all the then existing political systems in the world, we gave to ourselves democracy, a parliamentary form of democracy. And this democracy is the foundation of the Indian Constitution, and it has been declared so by our Honorable Supreme Court in the famous Keshwanand Bharti case. And this is declared the basic feature of the Indian Constitution that cannot be tinkered with, that cannot be altered by Parliament, even through the amending power that it is bestowed with under Article 368 of the Constitution. Now, this democracy is the catchword today, and it is this democracy in light whereof I'll be viewing the Constitution of India, and I would, on the basis of, on the touchstone of this democracy, democratic principles, I would like you to join me. I'll be just examining the 70 years of functioning, working of the Indian Constitution. Now friends, democracy, if you want to know it fully, it is in itself a complete discipline that would require months of study. But in a nutshell, if I give you a definition, it is a government by the institutions, democratic institutions, and run or guided by certain democratic principles, like the principle of separation of powers, that all the power should not be concentrated in one authority, rule of law, that all are equal before law and all are assured the equal protection of laws, as is enshrined in Article 14 of our Constitution. Separation of powers is Article 50. And then there is principle of checks and balances, that one institution, democratic institution, should act as a check on the authority, power of the other institution, and no institution should become overpowerful or dictatorial. There should be a kind of balance of power. Then there are democratic principles that still are evolving. In the recent past, we had that movement of the sunshine laws, that sun must shine on all the democratic institutions, on all the functioning of the state. Nothing should be in darkness. This Right to Information Act is a product of that moment, and more are evolving. So we are to ensure, the Constituent Assembly was to ensure this democracy to the people of this country. Now, you may say that all of us have read the definition of democracy in a high school, that is, it is government of the people, for the people, by the people. And if you ask me, in real terms, democracy is the government for humans, by humans. Democracy does not presume that we have gods and prophets ruling over us. Rather, it believes that we have human beings, peccable, fallible, who are in the position of power, and it strongly believes, there is a legal maxim, that power corrupts and absolute power corrupts absolutely. So no one in a position of power should abuse his power. For that, democracy creates a system through the principles of separation of powers, checks and balances, rule of law, so on and so forth. And now right to information is a very strong tool, a potent tool in the hands of common people to ensure nothing is shady in working of the government. Now, in the light of this all, now I would take up part 5 of the Constitution, and part 5 is from Article 52 to Article 151 of the Constitution, and from 124 to 146 it is the Supreme Court, that I'll take up some other day, and 148 to 151 is the institution of Comptroller and Auditor General of India, who audits the accounts of the government, because it's all the monies in the hands of government are our money, our revenues, so they can't spend it at their own whims. So they have to account for every single rupee. Then Article 76 is the Attorney General of India, who is the legal advisor to the Government of India, Union Government, and he represents government in all the legal matters. Then we come to the office of President of India. It is Article 52 to Article 62 of the Constitution. Now we know we are a democratic republic. This is what preamble says. So republic means our head of the state is, we have an elected head, and that is the President of India. He is the supreme commander of the defense forces. All the executive power of the union vests in him, and all the decisions of the union government are taken in his name, Article 77. And then the Prime Minister is to communicate to the President all the decisions of the government, Article 78. And then there is the power to pardon under Article 72. That is a great power, and with great responsibility, that he can pardon, and other he can provide like respite, reprieve, commutation, the change of sentence from one form to another. So this is the special power of the President. And then is the election of the President. Election of the President is through an electoral college. It is indirect election. It's quite similar, somewhat similar to the President of America, but there the electoral college is elected for the purpose of electing the President. Here we already have an electoral college that comprises all the elected members of Parliament, elected only, and elected members of all the legislative assemblies of the states, as well as the union territories that have their own legislative assemblies. Now, to ensure a uniformity in the election that is in the scale of representation that is granted to the states inter se and between union, the parliament, and states as a whole. A formula is evolved, that is, for every MLA, the votes that are assigned to each MLA is obtained by dividing the population of the state by the total number of MLAs, elected MLAs of the state, and then the quotient is again divided by 1000, and that figure is the number of votes that are assigned to each MLA. Now, all the votes assigned to the states together, they are divided by the total number of MPs, elected MPs in the Lok Sabha and Rajya Sabha together, and that would give, the quotient would give the number of votes that are assigned to each member of parliament. Now, you must have heard the election is through proportional representation through single transferable vote. So term is a bit tricky. It is actually that every voter, the elector, is to vote in order of preference. So he is to give his preference 1, 2, 3. So who is his first preference, second preference, third preference, and at the time of counting, the candidate who gets the maximum number of first preference votes would be elected if he gets the requisite number. Now, the requisite number is of all the total votes polled, that is divided by 2, that is the half mark is obtained, and that is 1 more is added to it, that is 50% plus 1. Now, in case no candidate gets that requisite number of votes, then the last candidate who gets the lowest number of the first preference votes, he is ousted. His votes are distributed amongst the remaining candidates in the order of second preference. Now, then on the basis of that, if some candidate gets the requisite number of votes, it will be elected, then the process would go on until we get the candidate. So this is his election. Then there is process of removal. Removal is also quite difficult. It is through the process of impeachment, and it is to be moved in either house by more than 1/4 of the total membership of the house. The resolution would be moved, and then the motion is to be voted upon, and by a majority of the vote of the 2/3 majority, that is 2/3 member should be present in the house, they should vote, and by majority vote he can be removed. So this is about the president. Then we have Vice President of India, and the Vice President is the ex officio chairman. Ex officio means by virtue of his office he is the chairman of the upper house, and he is elected by all the members of electoral college, comprises the members of both houses of parliament only, states are not involved, and he can be removed by a motion in the upper house, and that is to be approved by the lower house. So thereafter we come to the most powerful authority, and that is the Prime Minister in Council. Article 74, 75 and onwards. Now, in a constitution we have Prime Minister to aid and advise the President in discharge of his functions. Prime Minister is elected directly from a constituency, a large constituency, and he is the elected head of the largest political party in Parliament, and on his advice the ministers are appointed by President, And in the Council of Ministers, he is not primus inter pares, that is first among equals, but he is much superior, he enjoys much superior power than his colleagues in the Council of Ministers. And now this authority of Prime Minister, being head of the political party and being enjoying the support amongst the populace directly, lest this authority as Prime Minister should become an absolutist and subverting democracy and creating a kind of totalitarian state. Our constitutional makers constituted the institution of president. Now this office of president, he stands at a higher pedestal. He enjoys more moral authority. He enjoys the support of not only the government in power, but of the opposition, because all the legislative assemblies also vote for him and he should get more than 50% of the vote. Now he was to exercise his powers to check the unbridled, lest it should be unbridled power of the Prime Minister in office. But the thing has been that from the very beginning of the working of the Constitution, Prime Ministers in office have tried to encroach upon the powers of the presidents. Dr. Rajendra Prasad was very critical of it. And the final blow came by the 42nd Amendment of the Constitution. Earlier the clause, this Article 74 of the Constitution, it read that there shall be, you should be very particular about the words, so let me read. So there shall be Council of Ministers with Prime Minister at the head to aid and advise the President in the exercise of his functions. That's all. So this was the original article, but by virtue of this amendment, this clause 1 was substituted, and the section 13, it amended the article 74, and what we got is, there shall be Council of Ministers with Prime Minister at the head to aid and advise President, who shall in the exercise of his functions act in accordance with such advice. Now this 42nd Amendment has given such a blow to the Constitution of India, eroding the principle of checks and balances that was very delicately it made a part of this Constitution of India, that this Constitution, this whole edifice of the Constitution of India, it became lopsided. It tilted in favor of the Prime Minister, and because of that, all the maladies that we see afflicting our Constitution, afflicting our state, they are a product of that. Now what happened is that this reduced the office of President, this 42nd Amendment, reduced the office of President to that of a titular head, just a rubber stamp President who is to just put his seal on all the decisions that are taken by the Prime Minister. Now an argument is forwarded that because the Prime Minister in Council is answerable to the Parliament, so if you give the real power to the President and then make Prime Minister answerable, that creates a kind of anomaly. So I also thought over that. And firstly, the thing is why I argue that the president is not just the titular head. There are 2-3 points that I would like to make. One is, you see the election of the president. If he was to be made just a titular head, just like the monarch of England, he could have been nominated by the political party in power. Why such a vast election process, where all the states, the union, both the houses, they are involved, and elected members only? Secondly, you see his removal. It's through the process of impeachment. That process of removal is prescribed for the judges of the Supreme Court and High Court. See the immense powers that the Supreme Court and High Court judges enjoy. And in comparison, see the President of India. Thirdly, the oath. That's very important. It's only President and Vice President of India whose oaths are provided, incorporated in the Constitution itself. Rest all, including Prime Minister, even in the judges of the superior courts, their oaths are incorporated in 3rd schedule of the Constitution. Oath of the President shows that he is the guardian of the Constitution. It says that the President, he says that I will preserve, protect and defend the Constitution and law. Now these wordings, they are assigned to none else, not even the judges of the Supreme Court. They only say we uphold the Constitution. You believe this oath was just some literary composition that was made by some member of the Constituent Assembly? This was all deliberately incorporated. Even Vice President, whose oath is also in the Constitution, he also does not have this oath. So this oath says that President is the guardian of the Constitution of India. So he is to preserve, protect the Constitution. Now how this is to be done, this is my own view, this is my own suggestion, and the thinkers, the scholars, they can have their own suggestions on this point. There are in two capacities, President of India, he performs his duty. One is as head of the government, and another is as guardian of Constitution. So far as head of government is concerned, then whatever the decisions the government takes, he should normally accept those without much difficulty. Even their presidents have asserted themselves. We know of the presidents, former President Gyani Zail Singh, he withheld his assent because they don't have the power of veto like the President of America, but he exercised pocket veto because he said, I will not give assent because there is no time assigned to it. Then we have our President, Mr. Venkataraman. He refused to give assent to a bill that gave pensionary benefits to the members of parliament. He said this is nothing but self-aggrandizement. So in these matters, normally President should give his assent because Prime Minister is answerable to the parliament, so President should give his assent. But as the guardian of the Constitution, he should have his own say. Like we have the institutions of Comptroller and Auditor General, we have Election Commission, we have the judges of the superior courts, and we have governors. You see how much controversial these appointments have been. So in these appointments, President should have final say. I suggest that the government of the day It should suggest a panel of names. It should recommend a panel of names to the president, and the president, in consultation with the opposition parties, with the intelligence agencies, the media, and all he may like to consult. After consultations, he should make the final selection, appointments, and that should be open to judicial review. And if presidents can follow the precedent laid by former President Mr. K.R. Narayanan, that he would give even reasons. So what were the reasons to take a decision? So that would be better. And so far as judiciary is concerned, now NTSC has been struck down. We may have it in some amended form, or collegium system that is working together today. So the collegium may recommend a panel to the president, and he should make a final selection after consultations with all, even bar councils, they can be consulted. And that decision should not be open to judicial review, that be reviewed by some other authority. We need some judicial accountability commission or something that would review. And I believe if this is done, because when all these institutions, election commissions, CAG and others, when their appointments are made by the Prime Minister, surely they'll be Prime Minister, they'll be conformists. We understand. So that actually makes democracy very weak. So all that ails democracy, all the maladies, they are product of that. So I'm leaving you today with this thought that Section 13 needs to be done away with, or it be amended. Further, the Article 74, so that balance that is intricate, that is enshrined in the Constitution of India, that is inherent in our Constitution, that principle of checks and balances, that is re-ensured. And I believe our Constitution of India is the panacea for the maladies that afflict